Ladies and gentlemen, welcome to the webinar called Unpacking the POPIA Act, the Protection of Personal Information Act. Just taking a few more minutes for our guests to join us. We are nearly there. Wonderful. Ladies and gentlemen, my name is Louise Lepan, and I'm the Chief Director for Senior Management and Professional Development at the National School of Government. And it is my great pleasure to facilitate the session today with the National School of Government and the Information Regulator of South Africa partnership. We are delighted to have this opportunity to present the first of a three-part series to introduce you to the POPIA Act and for you to have an opportunity to engage with the Information Regulator directly. As part of our webinar, if I could give you a few rules, please can I ask that you keep your camera off, that you participate on the Q&A box at the bottom of your screen. Please post your questions, please post your comments and your input. And at the end of the session, we are going to post a link where we will ask you just to give us feedback on the actual session itself. We're looking forward to an informative session. It's a very short time together, and so let's get started. I would like to introduce our colleague, Mr. Dino Punsami, who is the acting branch head, the acting DDG for our branch at the National School of Government, just to make some opening and welcome remarks. Over to you, Dino.
Good afternoon, Program Director, Ms. Louise Lepan, and good afternoon to all of our invited guests and attendees today. I must say it's quite impressive when you look at the top corner of your screen and you see the participant numbers increasing. I'm looking at it now and it's in excess of 470 participants, which is quite phenomenal. So thank you to all of you who are here today, joining us at this very informative and very well-positioned webinar. And together with our colleagues from the Information Regulator South Africa, we thank you for being part of us on this all-important webinar and partnering with the National School of Government. As you would know, the National School of Government as a state training institution is very instrumental in building state capacity in this developmental state. And for us, always importantly, is making sure that we find the different instruments to enable the state capacity building process. And that allows us to fulfill our obligations as the National School of Government. As the school, we have an expanded mandate to provide education, training, and development in all organs of state as captured in Section 195 of our Constitution. And we do so in strong partnerships like the one we have today with the Information Regulator. Our mandate requires us to also expand on our products and service offerings beyond which we normally offer as our training programs. And in the past year and a half, we've sought very innovative ways of ensuring that we continue this journey of building capacity in the state, most notably now the webinars and the master classes. Of course, there are other programs that the school is now offering and which has become very entrenched, programs like New Kela, programs like the Ethics in the Public Service, as well as other programs that target members of the executive, like the seasonal schools on economic governance. We encourage the participants to visit our website and engage with us on some of more interesting program offerings, product offerings that we have as the school. And lastly, I think importantly is to reflect on partnerships, which are key for us as the National School of Government in strengthening our mandate. We do this by making sure that we have partnerships internationally and domestically. We have partnerships with many of our higher education institutions that allow us to tap into other products and service offerings that can be made available to the public servants. So Program Director, with that words, I would like to really welcome all of the participants as well as the guests who are here today, and we hope for fruitful discussions on this all-important webinar. Thank you, Program Director.
Thank you very much, Dino, and thank you for the kind words on what the school is doing to generate an awareness around ethical behavior and professionalism. Without further ado, colleagues, ladies and gentlemen, we'd like to know a little bit more about the information regulator. So I'm going to invite Advocate Lebogang Stroom Nzama to come and introduce the information regulator to us. Just a few words about her. She completed her LLB degree at the University of Pretoria. She began a career as a candidate attorney at Hack, Stupel and Ross Attorneys, where she completed her articles of clerkship. She was admitted as an attorney of the High Court. She further completed an LLM degree with specialization in commercial law at UNISA and a certificate in compliance management with the University of Johannesburg. Her previous work experience includes areas of legal, compliance, and risk at various financial institutions. In 2012, she was admitted as an advocate of the High Court of South Africa and a member of the Johannesburg Bar. She's currently the full-time member of the Information Regulator, and she's here to give us a short overview of the work of the Information Regulator South Africa. Over to you, Advocate.
Good afternoon, Program Director. Can you see me?
Yes, clearly.
Okay, thank you very much. Good afternoon, colleagues. And thank you very much, Program Director. And I would like to welcome our colleagues from the National School of Government. My name is Advocate Lebogang Stroom. I'm one of the full members of the Information Regulator. I would like to introduce to you my colleagues from the Information Regulator who are here today. Advocate Colin Weapond, it's one of our full-time members. Professor Sizwe Snell Kamduse, it's one of our part-time members. Mr. Dimba, it's our executive for education and communications, and also tend an apology for our chairperson, Advocate Pensi Tlakula, who couldn't be here today due to some personal commitments. The Information Regulator consists of 5 members, the chairperson, Advocate Pensi Tlakula, 2 full-time members, myself responsible for the Promotion of Access to Information Act, Advocate Weapond responsible for the Protection of Personal Information Act, Professor Sizwe Snell Kamduse, who is our part-time member, and Mrs. Alison Tilly, who is also our part-time member. We took office in 2016, and our mandate is that we are responsible for both the Protection of Personal Information Act and the Promotion of Access to Information Act. As you are aware, we took over the POPIA function from the South African Human Rights Commission as of the 30th of June this year. And the remaining sections of POPIA were promulgated by the President with effect from the 1st of July this year. Then POPIA came into full operation. Then we expect, by saying that we expect that all public and private bodies should comply with both POPIA and POPIA. We are amenable to cooperating and collaborating with other organizations and our sister organization to foster and to encourage the culture of compliance with POPIA and POPIA. In so doing, we still indeed maintain our independence in terms of our mandate. Thank you very much for allowing us today to be part of this session to empower and to learn from each other. With this, because we're going to have a detailed presentation on POPIA, I would like to hand over to the program director to continue with the business of the day. I thank you.
Thank you very much, Advocate Lebogang Stroom-Nzama, for that short overview of the work of the Information Regulator. From your input, I recognize that the responsibility for PAIA and POPI fall under your purview. So, ladies and gentlemen, the webinar outcomes for the session, for your participation, is that at the end of the session, you will have a broad understanding of the POPI Act, its implications for your departments, the conditions for the lawful processing of data, the necessary steps to become POPI compliant, and as well managing the risks associated with POPI. So we're going to now ask Professor Snehal Mthunzi to begin with the presentation, and he will manage that presentation with Advocate Colin Weapond. Let me give you a few words of introduction to Professor Sizwe Snehal Mthunzi. He's a senior partner at Snehal Attorneys at Law. He holds a BAc LLB from the University of Pretoria with tax law and cyber law electives. He also holds an LLM qualification from the University of South Africa and is currently registered with the University of Fort Hare for an LLD. He's very well read in cyber law. He's currently the international coordinator of the African Center for Cyber Law and Crime Prevention based in Kampala, Uganda. He's also co-editor and author of the third edition of Cyber Law at South Africa 3, and currently involved in the writing of the fourth edition, Cyber Law South Africa 4. He's the author of various articles on cyber law in accredited and non-accredited journals, both locally and internationally. He has given ad hoc lectures for, among others, the Law Society of South Africa, Association of Certified Fraud Examiners, and the University of Witwatersrand. He's currently the part-time member of the Information Regulator. Can I hand over to you, Prof, and you take it away?
Thank you very much for the kind introduction. I'm just waiting to be made host. Otherwise, I can't share my screen. But in the meantime, whilst I'm waiting for that to happen, I'll be giving you a small overview of the POPIA, part 1 in particular of this webinar session. Dealing with mostly the conditions for processing, some basic concepts. Let me see if I can do screen sharing. Yes, I can now. I trust you can see what is on the screen that I have as well.
Still loading.
Oh, is it still loading? Okay. Good.
Thank you, Prof. You can see it.
Okay. Thank you very much. So the presentation is called Presentation to Accounting Officers and Senior Management of Government Departments. I think I'm going to switch off my screen. You've seen me. I'm not being rude. Data's a little bit skanky today. It's not ideal. So if my screen is not off, it's not that I don't want to see you. Right. So what exactly is the purpose of the POPIA? Maybe one should start by actually saying what exactly is the POPIA? It's the Protection of Personal Information Act. And this particular act derives its powers from Section 14 in the Constitution. that deals with the right to privacy. Right. So the right to privacy is the right that allows you as an individual to have a private space free from government intrusion, free from intrusion from other individuals. And obviously, this right to privacy should be seen also in the context of the right to access to information, namely Section 32 of the Constitution, which allows for the protection, or should I say, the making accessible of information under certain circumstances. So the information regulator, as you see at the bottom right, that is the custodian in terms of Section 39 of the POPIA of these two rights. The one right, privacy, the other one, access to information. Right. Now, what is very important for you to understand is that the POPIA prescribes what we call the minimum threshold, or what we call in South Africa, the minimum requirement for lawful processing. In other jurisdictions around the world, we call them the conditions or the requirements, whatever you want to call it. These 8 conditions are the backbone of the POPIA. And these 8 conditions are consistent with the internationally accepted standards relating to data protection. So we may not necessarily be in line with the 2016 GDPR, because the POPIA was drafted way before 2013, but put into law in 2013. So you can accept that your Convention 108 is there, your EU directives have been looked at, your 1995 directives, and any other international best practice relating to the protection of personal information. So these 8 conditions are the ones that give you rights and remedies pertaining to the protection of personal information. I see there's 2 hands up. I'm not sure in terms of our procedure if I must entertain those now or if I must just proceed.
Please continue.
Okay, right. So the POPIA gives us certain rights as data subjects and certain remedies in the instances where there is an infringement or an interference. If you look at our Act, Section 37, sorry, 73, 37 deals with exemptions. Sections 73 and 74 deals with the instances where you can bring a complaint where there is an interference with the conditions. We will get to the conditions in a moment just now. And like I said, you know, the information regulator is here to enforce these 8 conditions. That is the beauty of the POPIA, as it has what we call a enforcement mechanism. Now, other provisions of the POPIA, and you will see this in Section 71, you will notice that in Section 71, there is a right of a data subject not to be adversely affected by an automated decision-making process. In other words, you may not take a decision about someone based entirely on electronic processing of their personal information without them actually participating in that process. I prefer to refer to the sections because I think the sections are very, very important, but I think the drafter of the slides was trying to keep it in plain legal language. So we're good with that as well. And what is important with the POPIA And I think there's a big misnomer. There's a big misnomer out there to say that there is the information regulator, there is this and that regulator, and that, and that they're all on par. I guess they are on par in the sense that there are regulators that have been entrusted to regulate certain parts of the law. But when it comes to the protection of personal information, when it comes to access to information, we can proudly say as the information regulator that we are the Uber, the overall regulator. You will recall during the Second World War, the Germans had a national anthem that used to say, Germany, Germany, über alles. So in this case, the Uber would be taken in context to say, you know, POPIA, POPIA, über alles, over everything, where it relates to the protection of personal information and access to information. I hope I'm not going too fast. I hope everyone is following. Now, there's some definitions that I just want us to get out of the way. They're very important. Otherwise, you will get lost whilst trying to understand this jargon. And this jargon needs to stay with you forever. So what I'm about to tell you now, this jargon needs to sit in the back of your mind forever, because this is the jargon that we're going to use going forward in terms of the POPIA. So you and I are data subjects. Interestingly enough, if you look at the definition of personal information and what is a person, it relates to a living person as well as a juristic person. And that's probably because of the vertical and horizontal application of our law and of our constitution. So in South Africa, we are the only jurisdiction that actually gives effect to data subjects in the form of juristic persons. In all other jurisdictions around the world, a data subject is a living natural person. But in terms of the POPIA, it also includes an existing natural person. Then I always get the question that says, all right, what exactly is an existing natural person? Well, an existing natural person will be a company, a partnership, a trust, any natural person that has legal status, the ability to sue and to be sued. Okay, so those are the data subjects. The responsible party, that is the, should I say, the opposite definition of the data controller. So the data controller, in terms of the GDPR or in terms of whatever other international best practice that you may have read or come across, the responsible party is the equivalent of the data controller. This is the party that processes the personal information of the data subject. This is the party that initially collects the personal information from the data subject and then processes it for the purpose that it would have obviously disclosed to the data subject. Then number three, we have the operator, and that would be synonymous with a data processor. Okay, so the data processor is the party, or the operator is the party that processes personal information of the data subject for and on behalf of the responsible party. I'd like to stop at this juncture and make reference to the case, the well-known case of the Black Sash versus SASSA and others, where the information regulator was respondent number 8. Now, what Black Sash sought to do there was to protect the personal information of data subjects that was being abused by the operator. Black Sash was trying to suggest that the responsible party, that being SASSA, that they are the owners of the personal information, hence they must protect the personal information of the data subject. We could see through what Black Sash wanted. In fact, they were quite right about the protection of the data subject, but they were slightly wrong about the responsible party. The data subject, and that's what we said in our explanatory affidavit, which was accepted by the Constitutional Court, the data subject remains the owner of the personal information. However, the responsible party has certain duties, such as keeping the information safe, having a written agreement with the operator that processes this information to ensure that the personal information is treated with the same safety and with the same confidentiality at the same standard that the responsible party would be held. So somewhere at the end of that long judgment, you will find one or two paragraphs in the constitutional judgment where the court said that SASSA, as the responsible party, has a duty to protect the data subject's personal information and ensure that it is not subject to further use that is unauthorized or other uncalled for unlawful use. Now, the POPIA applies to everybody. Public bodies, private bodies. For those of you who have a copy of the POPIA, please go and look at the definition of the POPIA. Since this is a three-part webinar, I would strongly suggest that whenever you come and join this webinar, you have a printed copy of the POPIA next to you, because the POPIA has close to 120 sections. And if you don't follow what is being said in this webinar in conjunction with the POPIA next to you, you may become slightly confused. But the 8 conditions start from section 8 right up to section 25, section 8 to section 25. We do have obviously other sections like section 6 and section 7 that talk about the exclusions to POPIA, but those will be dealt with later. So from section 8, we have the principle of accountability. That says you are accountable for the data subject's personal information. And number 2, we have the processing limitation. Now, processing limitation is multifold. It talks about the lawful processing of information. It talks about the consent requirement. You must get the consent. And when you look at consent, consent must be read together with the definition of consent. It is specific, voluntary, and you must be aware of what you are consenting to. And then obviously there must be lawful purpose. So there are lawful purposes where the law says you may process, where there's a public law duty, where there's a contractual agreement where you need to process, or where the processing has a clear benefit for the data subject. But those are some of the exclusions, as well as things like research and statistical use, historical analysis of data. But most of this must then be done in anonymized versions and at strict controls with regards to the safety of the data. Condition 3 talks about purpose specific. You must only process personal information for a specific purpose. So you cannot, as the NSG, collect my phone number and my email address, purporting to collect them to register my information to attend in the seminar. And then the next thing I see is that an official of the NSG unlawfully has shared the information with his cousin James. By the way, cousin James is a fictitious cousin. We use him always when I teach. Cousin James is that guy who works for an insurance company who always wants leads. And unfortunately, his cousin Tom, who works at the NSG, and as I'm saying, this is a hypothetical, please, no offense to the NSG. Cousin Tom, who works at the NSG, has access to the 672 participants, as I see here right now, that are attending, and he gives this information to his cousin. That would not be permissible because the information was collected specifically for the purpose of registering and having participation in this webinar. There is, however, a section that deals with further processing, and the further processing provision says if you do further process, if you do happen to engage in further processing of personal information, there is a duty to ensure that it is compatible with the initial purpose that you collected it for. It must be compatible with the initial purpose that you collected for. And there's a whole test set out in there. Maybe just go back to purpose specific. Think section 14 or section 16. I stand corrected. Talks about retention. It says you may only keep the personal information for a period for as long as you still need it for the purpose that you collected it for. So we have an implied right to be forgotten. For those of you who've read the case of the Spanish lawyer against Google, where the European Court of Justice spoke that you have a right to be forgotten. So the POPIA says you must retain the information for as long as you need it, for as long as the law tells you to keep it, and after that, you must destroy it. Information quality, you must have up-to-date, correct information. This is somehow bringing in the positive duties that we have in FICA and in RICA, for instance. The bank must know where you stay, and they must from time to time check by getting your latest water and lights and so forth. So if you are keeping personal information, if you are processing personal information, because that's the word that we use, we don't keep, we don't use, we process. Keeping, using, collating, and as you will see later on, these are all acts of processing, right? Openness. So if you process my personal information, there's a positive duty that you must notify me. At some stage, I must either get an email notifying me, or if I go onto a website, or even better, when you came onto this Skype recording, there was a notification where you were notified that this particular webinar would be recorded. And if you look, obviously the participants and names are there of the attendees. Some of the participants have obviously used fake names, but generally speaking, if you go to the participants section, you can usually spy and find out who is here and who is not here. But like I said, even on websites, you get now the cookie notification of late. The cookie notification is the one that talks about, in particular, notifying data subjects that their personal information is being processed. Okay, then going further, I hope everyone's sound is okay. Prof. Rampasad, is the sound good?
Yes, thank you.
Okay. Then we have condition number 7. This is the one that deals with the security safeguards. And it is embodied in sections 19, 20, 21, 22, right up to 23. So 19 talks about having appropriate technical as well as organizational safeguards, right? Appropriate technical and organizational safeguards. Technical is your software, your hardware, organizational is the human factor, the you and me factor, right? Having systems in place, having policies in place, ensuring that these policies pertaining to data protection are respected and are being properly applied, right? So these are the safeguards as envisaged by Section 19. Then Section 19.2 talks about the internal and external risks that you have, that you must assess, and the duty to have policies and to do an assessment of your policies and whether they are still up to date and applicable. When going to sections 20 and 21, this goes to the written agreement. So after the court case of the Black Sash, the post office, for instance, took over the service. But before that, Net1 and CPS had to enter into a written agreement with SASSA that they will protect the personal information and not use it for purposes other than that they had been entrusted with. A very interesting development. And then 21, the data breaches. Okay. I happen to be using Telkom. I know Telkom were breached. We can see how their connection speeds are. I'm actually one of the few people who still use the service. So Telkom, for instance, was breached, and they had a positive duty to notify to the data subjects, number one, that people, we've been breached. And unfortunately, you data subject, you Sizwe Snail, your data unfortunately was compromised. And they were kind enough to actually send me a message, or should I say to my firm, because it was my company's internet connection. So they got that right. I'm not at liberty to say whether they've self-reported to the information regulator. I think that would be inappropriate. But in terms of the law, they also have a positive duty once self-reporting to the data subject to self-report the incident to the information regulator, which may then want to find out what happened, what steps have you taken to fix it, and who was the perpetrator, and so forth. All of this you find in sections 21, 22, up to 23. Then data subject participation. This is your right to ask for erasure, deletion of your personal information at any stage, unless it is still being
Prof, are you there?
or a lawful, perfectly important personal information of data as prescribed. Like I said, in line with the 8 conditions as prescribed by the POPIA. Now, what is also very important, as you can see from the slide, a self-assessment, a type of audit needs to take place in terms of which, you need to make a self-assessment as to how you are collecting, how you are recording, how you are storing personal information. And as a result of that, you must be able to know where the leakages are, whether you are applying proper safety and security guards as well. Obviously, regular training in terms of the POPIA is also paramount. In other words, you can't just expect people in your organization to wake up and to know what the POPIA is all about. It is an educational curve, right? It is an educational curve that all of us need to take. And in line with this educational curve, one needs to make sure that from a compliance perspective, one literally is ticking all the box. Now, I just want to go back to here, right? So in terms of section 55 and 50, no, sorry, my apologies. In terms of section 60, 68, we have what we call codes of conduct. I would encourage you to please go on the website of the Information Regulator, where you will get the guideline in the development of codes of conduct. So these codes of conduct are not just for the taking. You will see in certain jurisdictions, codes of conduct, there may be 2 or 3. It is very rare where you have more than 5 codes of conduct. And you usually see these in the telecoms industries, the banking, the financial sector, and the health sector, where a functional equivalent is sought in the code to comply with the 8 conditions. But please, I encourage you, go to the guideline on the development of codes of conduct. You will find that on our website. Then we have also section 55 and 56, which is what I was trying to refer to earlier on. Section 55 and 56, the information officer. This is the same information officer as envisaged by the PIA. However, this information officer is not just for public bodies, but he also applies to private bodies. And this information officer is de facto the CEO or the head of department of that government organization. He or she may then also delegate to a deputy information officer. And once again, there is a guideline that the information regulator has written out to explain who exactly is the information officer. What are the duties and the responsibilities of the information officer as envisaged by 55 and 56, as well as the whole concept of having to register the information officer and the deputy information officers with the office of the regulator, and also the fact that the information officer will become the one-stop shop for the organization for any complaints relating to protection of personal information or access to information. Then we also have the concept of prior authorization and exemption. I think it would be appropriate to start with start with exemption. Just to go in a chronological manner for those of you who are following, right? If you look at section 37, 37 talks about public interest, a public body that's in the public interest for public security, the prevention of crimes, the prevention of terrorism may apply to the regulator for an exemption, for a complete exemption or part exemption of the application of the POPIA. So that is 37 to 38. This must not be confused with 57 to 58. This is the concept of prior authorization. This is the concept where you have collected personal information for one particular purpose, but you have ended up using that information and other unique identifiers and other data sets, and you've put them together, and now you're not using them anymore for the initial collection, but for other collection that was not authorized for. And if you are in the scheme of doing that type of business, if your business, unfortunately, essentially does that, the mixing and matching of data sets and unique identifiers, then you must ask for prior authorization from the information regulator. And last but not least, on this page, the concepts relating to special personal information. Now, what exactly is special personal information? This relates to information that you have about someone's union membership, information about someone's philosophical beliefs, their sexual orientation, their health status, their political alignment, and as well as the protection of information of children, right? So special protection has been given to these categories of information. Then I see now, and I think this is where I'm supposed to end for my part. There's a further explanation about the status of the information officer, right? The status of the information officer, and as I've said to you, the de facto information officer would be the head of that organization, and they would then basically have the powers to delegate to another deputy information officer. So I know it was a lot of information to digest, but that is where we are right now. I see my colleague is not yet online, so maybe I must just continue on this note, right?
Prof, if you don't mind, can we just pause and take some questions?
Yeah, sure, you can do that.
Okay, great. Thank you very much for the input thus far. A lot of technical detail, Prof. There's quite a lot of activity on the QA box. So maybe just to translate some of the legalese into the daily action of a senior manager or a public servant. If you are, and this is a question from one of our colleagues, if you are serving in the public service, you are responsible to give effect to POPIA principles. Would this then allow, for you to share your cell phone number as part of the work that you are responsible for? Would it be allowed that you could share the cell phone number? And in the same light, could you share the attendance register for this meeting? So this particular session is recorded. This particular session has a registration form. Will we, the School of Government, be allowed to share the attendance register? And then the last question is, would the slides be available for sharing after the session? Let me just pause there. Over to you, Prof.
Okay, I see the question about the slides. I'm not the author of the slides.
Maybe Advocate Stroom would know better.
But most surely we will make it. but I will ask that these slides be available to the participants. On the question of whether or not the attendance register can be shared, that is a big no-no. That is an extremely big no-no in terms of the third and the fourth principle. You'll recall I specifically used this example of the collection of personal information for the seminar, and the example of the insurance guy and his cousin and the NSG employee. The attendance register for this event ends with this event, unless for the purposes of this event, the organizer of this event, and I'm sorry for emphasizing, wants to share the slides or the video from this event. In other words, anything related to this event, you know, you may not go further and use this attendance register for either checking who was here, catching up with old buddies. You know, if you want to do that, I'm not encouraging it, but go into the participants list and direct message the people. But no, the organizers may not share this list. And then what was the third question there again?
Then it was just around the sharing of the slides and sharing of the cell phone numbers.
Okay, like I said, any form of sharing that has not been authorized is not appropriate. So I think we should leave it at that for now. By the way, Chair, I see there's more questions on your Q&A there.
Yes.
Are we going to deal with those as well?
Yes. Taking them in batches of 3, so we're going through them slowly.
Okay.
There's a question from Anthony Oliver, who's asking if a divorced parent is required to provide the other parent's details in order to obtain medical assistance for their shared child, may they do so without the consent of the other parent? And there's a question relating to the information officer being the head of the public institution. Would this hold true with a Schedule C institution, where the head of the institution is the CEO?
You know what, this question about divorced parents is an interesting one, because, you know, we've recently dealt with a complaint where a parent was complaining about the disclosure of his non-payment of school fees and the school having gone to another parent, you know? So because it's a case that's currently being dealt with by the regulator, Anthony, I'll have to respectfully decline that one, because, you know, there has to be a uniform answer to these things, right? I see Advocate Sturm is there. Do you want to say something?
Yes, Prof. I share the same sentiments. Issues of children and divorces are very sensitive, and we haven't even tested them practically in terms of how POPIA would apply, because I mean, here is the consent of the other parent who is divorced, but it's in relation to a minor child, and information relating to a minor child is special personal information. I think at this point in time, we can't give a yes or a no on the answer, but following up, Prof, if I may, on the next question of whether a Schedule 3C company, whether the information officer thereof is a CEO. Yes, look at we have issued the guidelines, the guidance note on information officers and deputy information officers. You'll see under public bodies or department or government organs of state, if it's a public institution, the CEO of that institution or the person who's acting as such will be the information officer. Thank you.
Thank you very much, Advocate Sturm. The question is, the portal for registration of information officers, is that now operational?
Mr. Dimba, from an administrative level, can you maybe somebody or somebody in your team give feedback on the portal in light of the breach that was suffered by the Department of Justice?
Thank you, Advocate Sturm. Yes, indeed, we've had problems and difficulties with the registration portal for information officers. And it has been made worse by the recent security compromise that the Department of Justice, which hosts the portal, has experienced. So the regulator is in a process currently of migrating its IT systems as well as email systems into an own domain, which is now active. And we're in the final stages of reloading the portal and activating it under the new domain that is operated exclusively by the regulator. So look out for messages on this in a few weeks, maybe a month tops. We'll be able to announce formally that the portal is up and running. But I need to just add, if I may, Advocate Stroom, that there shouldn't be a rush to try and get information officers registered. We have provided leeway in terms of that. So there is no pressure on information officers to try and get registered as soon as possible. We will be sending out messages in due course regarding when the site is up and when can people start registering. Thank you.
Thank you very much, Mr. Dimba. Advocate Advocate Kamtuzi, I have a rather technical question here, and then we're going to continue with the presentation. It says, can you kindly explain section 3.1b, point, the applicability of POPIA to responsible parties that are not domiciled in South Africa? The understanding is that POPIA will be applicable to a responsible party not domiciled in South Africa, but who nevertheless processes personal information by automated means in response to instruction. What constitutes any equipment capable of operating automatically in response to instructions? If a prospective student, for example, applies online for registration on an academic course with an institution domiciled in the USA, how does the definition of automated means apply? If the institution has no servers or equipment in South Africa, can it be stated that the institution uses the equipment, laptop or computer, of the prospective student to process the student's personal information? And must the institution accordingly comply with POPIA?
I'm going to take that one. As much as in terms of sections 40, the regulator has a duty to give education to anyone or advice to anyone that would like to know. The question that has been asked there, relation to 3.1b Roman 2, it's a very technical question where I'm afraid, you know, if I'm going to answer that one in the way in which you want me to answer it, I may be burning my fingers and get into trouble with my colleagues. But the short and sweet of it is that as long as you're processing personal information of a South African, whether outside the Republic by electronic means or from a website that is in the Republic, processing a foreigner's data, right? In essence, where there's that causal link between the Republic and the responsible party and the data, the POPIA will most likely apply. So that is the, should I say, the politically correct answer. I wish I could give you a more precise answer as to what exactly is equipment capable of operating automatically. I mean, these are definitely interpretations of the law, which, as I'm saying, if I were to go into them, and I'd be most likely very keen to go into them, I'll get into far hot water with my colleagues. Advocate Stroom, I see your hand is up.
No, sorry, Prof. I've got a problem with my button here. So excuse me. I've asked Nomzamo to ask the host to lower my hand down. Thank you.
Oh, okay. All right. So Zelmani, that's the politically correct answer. You know, as long as you're using your cell phone, your laptop within the Republic, whether with a foreign service provider or or a foreigner accessing a South African website or social media, network or software, in either instance, the POPIA will be applicable. It is not the extraterritorial, application of the POPIA as envisaged by the GDPR. It is, however, almost likely to the extraterritorial application of the GDPR. And I think that concludes my part of today's presentation. I'll be handing over now to my colleague, Advocate Whippen. Advocate Whippen, are you there?
Good afternoon, Prof. Good afternoon, good afternoon to the DG and everyone that's part of the meeting, all participants. Thank you so much, and apologies for the delayed joining of the meeting. Thank you so much, Prof. Chair of the meeting, I'm just going to start where Prof left off. Thank you so much, Prof. So the duties, responsibilities of an information officer. So it's safe to say that we need to start at the beginning. Basically, Section 55 and Section 56 informs the duties and responsibilities of an information officer. But what is very important is that the information regulator has issued a guidance note, and this guidance note actually provides a basis on how and the type of person that would be reasonably suitable for appointment as an information officer or a deputy information officer. That becomes very critical. And what is also very important contained in the guidance note is the fact that the regulator did, in its understanding, provide broad guidelines and refrain from being specific with regards to a suitable person. Safe to say that a reasonable understanding of the business activities of the responsible party, as well as some insight into legal, would assist that specific person who will be acting as a deputy information officer. An information officer is basically appointed by virtue of his or her appointment as a chief executive officer or the DG or the HOD of a government department or provincial department. What is also very important for us to appreciate is the fact that this specific compliance, this specific information officer must ensure that a specific institution have what we would call a compliance framework. Advocate Stroom in previous meetings at the information regulator made an example about an integrated compliance framework that is usually used within the financial sector, such as banks. But what is also very important, if you also have to comply with various other pieces of legislation, it then becomes opportune to have an integrated compliance framework. So the compliance framework that we are referring to here is just the framework that outlines your processing activities in relation and in compliance with the 8 conditions for lawful processing of personal information. And what is very important before you do such a framework is to actually start by doing a gap analysis. Some call it a privacy impact assessment. Others call it a personal information impact assessment. This specific assessment assists the institution to actually identify all the gaps, and those gaps will then be mitigated with a proposed control or a mitigation measure. And that will then complete the processing activities of a specific institution. What is very important about this is that you need to divide your compliance framework into 2 aspects. The first aspect relates to your electronic processing. Your electronic processing is all the processing that will happen by way and by means of a computer gadget of some sort. But then you have your physical or your traditional processing that is now also referred to as your hard copy paper-based processing, where you, like in the olden days, walk around with a file which contain personal information of various data subjects. So those are the two aspects that you need to look at when you derive or when you do your compliance framework and your gap analysis. But what is also very critical to distinguish is your core from your support. Your core is actually the tasks that you fulfill in delivering a service if you are government based. But also your support are your HR processes, your finance, and all those other processes that assist you to achieve your core. And those two processes are very much interrelated and integrated. And for you to have your compliance framework completed, you need to ensure that you then distinguish properly between these different processes. What is also very important to appreciate is that the information regulator is considering, as we speak, also its new portal. And this new portal that they are busy developing will then enable information officers to register in terms of section 55(2) of the of POPIA with the information regulator. And after registration, according to section 55(2), will information officers be able to take up their responsibilities in terms of the Protection of Personal Information Act. That is a very important aspect that we need to highlight. What is also very important to appreciate under bullet number 3 is that there must be a POPIA manual that is developed, monitored, and maintained. And very important is the fact that there must be continuous updates as and when required, and also for that updated manual to be published on the institution's website for purposes of ease of reference and accessibility. What is also important to appreciate, and I've mentioned this, the last bullet, is that information officers must be registered in terms of section 55(2) with the information regulator. Next slide, please. So what we now see here is the issue of risk. And risk is very important, especially with regards to the Transnet data breach that we have just seen now, and also the fact that many opportunities for compliance lapses or unauthorized access of information has occurred and continues to occur. Another example is the data breach that occurred at the Department of Justice and Constitutional Development. And that specific data breach is a point in case for us to ensure that our risk management processes are developed in terms of section 19(2), which requires that any and every institution develop a risk management, a risk assessment plan, taking into account all its internal and external risk exposure. And that internal and external risk exposure must then be properly mitigated. And what risk exposure are we referring to? If you read section 19(1), section 19(2), it actually refers you to section 19(1). And section 19(1) refers to unauthorized access, which refers to a breach or loss of information, and any other access that might compromise the safety and the safe storage of information on the systems of a responsible party. And that becomes very critical, that you need to develop a risk management plan, a risk management conduct a risk management assessment in terms of section 19(2), and it becomes a compliance requirement, a statutory requirement in terms of POPIA section 19(2). What is also very important about this risk measures that you put in place is that you need to ensure that after developing, implementing, monitoring, and continuously updating it, that you maintain it continuously as and when your environment changes. And what is also very important to appreciate about the risk register is the fact that whenever your systems changes, I'm talking here about your electronic systems, you also need to go back and see if there's any other risks that might or could arise. And what is also very prudent to do before you develop a new system is maybe to take guidance and advice as way of and by way of best practice from the United Kingdom or the UK, where they have initiatives such as privacy by design. That means that you need to design your systems taking into account the 8 conditions for lawful processing of personal information. And that will help you to mitigate the risk of contravention or violation of any of the 8 conditions for lawful processing by way of guidance. Next slide, please. So what then happens is that we now need to look at the enforcement powers of the information regulator, and those powers are usually contained in section 73 to 99, but safe to say that section 73 then refers to certain violations of the Protection of Personal Information Act that could then result in what we would call an offense, and that is then the regulator then goes into what we would term as a pre-investigation to determine if there are reasonable and sufficient grounds for a full investigation. And after that determination has been made, then the information regulator would then continue with such an investigation. By way of an example, Section 73 refers to Section 22, and Section 22, by way of an example, refers to security compromise in what we know as a data breach. A data breach is then the one that I've referred to in terms of Section 19.2 and Section 19.1. And what is also very important to appreciate about it is that if a data breach has been experienced, by way of an example, then the information regulator can institute a pre-investigation and then a full investigation if a complaint is made to the information regulator in terms of Section 74. After the regulator has considered the complaint and done its pre and full investigation, a report will then be referred to the Enforcement Committee for consideration. The Enforcement Committee, in the regulator's understanding and mind, in terms of POPIA, can be chaired by an advocate or magistrate with no less than 10 years experience or a retired judge. So the regulator is in the process of considering such a person suitable as a chair for the Enforcement Committee. But what is also very important to appreciate is that this specific committee will be completed by appointing other members of the committee to assist the specific chairperson to execute his or her duties in terms of POPIA. But what is also very important about the fact that the regulator can conduct an investigation is that the regulator has the power to issue a summons, to administer oath, and to also conduct searches and seizures, and then also ensure that on the premises, obviously, of that specific responsible party. And that process of attending to a search and seizure will be that the officer from the information officer's side or the official will be accompanied by by the South African Police Services to assist with that process to finalize such an exercise. What is also very important to appreciate about the regulator's powers is that the Enforcement Committee, after it has considered an investigation, will now go and make a ruling and recommendations. And that specific ruling and recommendations will then be referred to the 5 members of the information regulator. The members of the information regulator can either accept the ruling or change it after consideration, but also accept the recommendations or change the recommendations before the final outcome of that specific ruling is issued to the affected parties, being the complainant on the one side and the responsible party on the other side. What is also very important to appreciate about the information regulator's processes is that the information regulator can issue an enforcement notice, and that enforcement notice can either request that the responsible party stop processing information of a specific data subject, or to stop interfering with such processing. And what is also very important about the enforcement notice is that specified notice can be issued for a specific period, and that specific notice can then direct the responsible party to do something or to stop doing something. And that in itself confirms how the regulator will manage and issue enforcement notices. Next slide, please. So now what we found, next slide, please. Yes, thank you. So now what we have is that a responsible party, after the information regulator has issued such a notice, may apply in writing to the regulator for the cancellation or the variation of that notice, depending on the circumstances. A responsible party can also lodge an appeal to the High Court, and that appeal is contained in Section 97 of the Protection of Personal Information Act. And what is also very important to appreciate is that a complainant who is not satisfied with the decision of a regulator can then approach the High Court to either cancel or vary an enforcement notice, and also then lodge an appeal. And we usually call it a review in the High Court, and those steps are contained in Section 97. Next slide, please. So civil remedies. So Section 99 refers us directly to what is the meaning of a civil remedy. In Section 99, you will find that any data subject may institute a claim against a responsible party, like yourselves, for damages in a court having the appropriate jurisdiction. Where interference or undue interference or interference that contravenes the provisions of POPIA in terms of Section 73 has occurred, and the information regulator can assist the data subject in filing and lodging such a civil case or action against the responsible party and in support of the data subject's claim. And that now confirms that there are further recourse beyond the regulator in higher courts, where a responsible party can still find, where a data subject or a complainant can still get appropriate relief. And the information regulator in terms of Section 99 is required to assist such a person. Thank you. Next slide, please. So I'm not going to dwell much, and I don't want to scare anyone. Safe to say that Section 107, in the interest of time and to allow for proper questions, contain what we find fines and penalties. So the highest fine that the information regulator can determine in terms of Section 107 is a fine of up to 10 million. And there could be a criminal sanction which can be pursued by the NPA for a maximum period of 10 years. Or it can be a fine of up to 10 million and a criminal action of up to 10 years. It can be a combination of both as the highest level of fines that the regulator can issue, or a sanction of imprisonment that the NPA can determine for a violation of the Protection of Personal Information Act. Next slide, please. So what is also very important to appreciate is that contraventions which are quite serious in nature are contained in Section 73. And those type of interferences with the processing of personal information can then result in these fines that I've just mentioned. Next slide, please. So what we also find is that the information regulator can also issue an infringement notice, and that specific infringement notice must specify the name and address of the infringer and the particulars of the alleged offense that he or she or the responsible party have committed. And as I've mentioned before, the type of fine, the maximum, and also what is very important to appreciate is that this amount may be adjusted of up to 10 million by the Minister of Justice and Correctional Services after consultation with the information regulator by way of issuing a notice in the Government Gazette in accordance with the average of the Consumer Price Index as provided for in Section 109 and 10 of POPIA. Next slide, please. So what is also very important to appreciate is the fact that the fine that has been issued or could be issued must then be paid into the National Revenue Fund, the NRF, for the processes that Treasury undertakes on an annual basis. Next slide, please. Yeah, so in conclusion, it becomes very important that responsible parties appreciate the provisions, unpack the provisions of POPIA, and just by way of mentioning, the Act is constructed along 5 very important aspects that you need to consider. So the first aspect would relate to exclusions, and the second aspect would relate to exemptions. And the third aspect would relate to an application for prior authorization. And the fourth aspect would relate to codes of conduct. And the fifth aspect would relate to guidelines that the information regulator issues with regards to codes of conduct and how codes of conduct can be developed. So on this basis of either using any or a combination of instruments, you can then, as part of your duties, ensure that you use, for instance, if you are a government entity, some exception or some exclusion or some exemption or prior authorization or the codes of conduct for the purposes of complying with the provisions of POPIA, but using the available instrument to guide you where compliance in certain circumstances are not possible. And just by way of an example, it occurred before where the Department of Health had to use databases in order to have the information of healthcare workers readily available. And the Act requires that you source that specific information directly from the data subject, and you must have the consent of the data subject. But there are also exceptions that allows the department, after seeking guidance from the information regulator, to actually embark on such a process using these instruments to actually use an exception to achieve its target of having the necessary information readily available to conduct the COVID-19 vaccination processes. Colleagues, I'm going to stop there, and thank you, Prof, and thank you, Advocate, and also thank you to the DG and participants on the platform. Thank you so much. Over to you.
Thank you very much, Advocate Colin Wetland, for that detailed input. Please, can I just give you your short bio, because the information that you shared with us was really detailed and very applicable to the public service. Advocate Wetland is an admitted advocate of the High Court of South Africa. His areas of specialization include information technology, risk management, forensic investigation, compliance management, business management, and law, with specialization in the law of contracts. He's currently serving as the chairperson of the Audit Committee of the Office of the Premier in the Eastern Cape and chairperson of the Risk Management Committee of the Department of Telecommunications and Postal Services. He also serves as a member of the Limpopo Province Audit Committee, Wholesale and Retail SETA, and the Free State Department of Education. He is appointed as the independent expert for legal and ICT at the Quality Council for Trade and Occupations, and is currently serving as the full-time member of the Information Regulator. So thank you very much, Advocate Colin Weapent, for that input. We've got a slew of questions in the quality question and answer box. Maybe just to kick off is to recognize that the POPI directly impacts all public servants, more especially supply chain managers, HR managers who are responsible for interviews or maintaining data subject information, and then perhaps also in the education sector where you have research that is required. So one of the questions out of the box was to ask, as a supply chain manager, they have to make information available of the suppliers. Is this allowed? Are they allowed to make the information available for the suppliers? Let's just pause there and then I will open to the other questions. Advocate, over to you. Advocate Weapent.
And let me start before my colleague, Advocate Weapon, comes in. What type of information from the suppliers are they publishing? Are they publishing the names, the tender numbers, the address? What are they publishing actually of the suppliers?
In the box, it was just to indicate that they make the supplier information available. Remember, when the supply chain processes work out, you use the CSD and as well your request for proposals. Let me pause there.
Yeah, and I think I should draw attention to condition 2, which is number 10 on minimality. You can process personal information, but given the purpose for which it is processed, but it must be adequate, relevant, and not excessive. For an example, these gated communities, you come in, you fill in your registration number, vehicle registration number, ID number, your name, your telephone number. That's excessive processing. So I don't know how you as the department are you going to align what you publish with the principles of minimality in terms of condition 2 of POPIA. Thank you.
Thank you very much, Advocate Strom. Anything from you, Advocate Weapent?
Thank you so much. I think Advocate Strom has covered me, and safe to say that many of these processes must then be tested and comply in terms of the requirements that Advocate Strom has highlighted. Thank you so much.
Thank you very much. There's a number of questions in the QA. Is there another way in which institutions can establish who of their delegates have attended for record purposes? So this has become quite a popular question. Prof. Kamtuzi said, we cannot make the register available, but the way the NSG works is that the participants come to the class, they sign an attendance register, and the coordinator back at the office requests a copy of the register. Prof. Kamtuzi says this is not allowed according to POPIA.
Yes, if you're doing that and people are obviously with POPIA having come into effect, you have to tell people has to consent to put their names, their details there. If you're saying you're making a copy for safekeeping, the question now comes, what if that register get lost? It's a breach, isn't it? So if maybe you keep that register, because I would agree with Prof that is not allowed, we must find ways. But if you're keeping it as for record purposes, you must ensure that the security, it cannot be compromised from a security point of view. So the question is that what if that paper, that copy that you have made get lost with all that information? Thank you.
Thank you very much. Principal, can I ask you to speak your question there? You've got a question about government communicators.
Yes, no, thanks. My question, which I posted there, is the do's and the don'ts for government communicators. So the majority of the colleagues who are attending here, and you can see by the line of questioning, are colleagues from legal services, internal audit, and other functions that are ordinarily compliance driven, and they take an interest because they are responsible for those. Some of them are deputy information officers. We then have this other cohort of colleagues who are in the communication space, those who are supporting political principals. They may be going around with them on an imbizo or any other government business. They take pictures and they post those pictures on social media. It could even be someone who just is standing behind the principal, and sometimes there could even be a registration plate of a motor vehicle of someone who has nothing to do with that particular event. What happens in such circumstances? Thank you.
Thank you very much.
Thank you, Principal. Advocate?
Yeah, if I may go, that is not allowed in terms of POPIA. Before you take a person's picture, you need consent of that person. For an example, it's going to also affect the schools where you find that they're making newsletters, they're taking pictures of the kids, putting together in a new newsletter, or maybe on a bus, advertising the school with the faces and the pictures of the kids, whether be it sports, be it whatever activity at school. That is not allowed. Even now, in your instances that you have made, sir, you cannot take pictures and disseminate and publish them without the consent of the person who you're taking the picture of. Thank you. Advocate Weapon.
Thank you, Advocate Stroom. I think you've covered me again, and safe to say that whenever consent is a requirement, and whether you need to collect directly from the data subject, those principles must be complied with, and also ensure that these processes are built into your policies, such as your records management policy and your document control policies and all other relevant policies. Thank you so much.
Jabulani Kamalo says, is there any feedback from WhatsApp and Facebook on its terms and conditions which are contrary to POPIA? Should we continue using WhatsApp as government employees or cancel this until this issue is settled? So many government departments use WhatsApp as a form of fast and immediate communication. How does that impact us in terms of POPIA?
Advocate Weapons, I think the WhatsApp and Facebook matter you can give feedback on.
Thank you so much. So basically the regulator is continuing its engagement with WhatsApp. Obviously that process is continuing, but for now the regulator has sought a legal opinion and is considering the legal opinion in order to further engage WhatsApp. But what is also very important to appreciate at this stage is that various other jurisdictions have issued fines with regards to the privacy policies or the updated privacy policies, like your island regulator and so on. But what is also very important to appreciate at this stage is that the regulator will at the necessary time communicate its outcome, but also the regulator cannot at this stage give guidance or provide direction to anyone to use or not to use Facebook or WhatsApp. Thank you.
Thank you very much. There's a question from the Deeds Office. Dealing with the Deeds Registry Act in particular, the Registrar of Deeds is empowered to permit any person to inspect the public registers and other public records in his or her registry other than the index to such registers, and to make copies of those records or extracts from these registers, and to obtain such other information concerning deeds or other documents registered or filed in the registry. So how does POPIA impact us? Given that we are over 80,000 persons who have passed away due to COVID, and many families are having to deal with estates, how does POPIA affect us in that regard?
Advocate Weapon, if I may, if you recall, sometime in 2017, we had representatives from the Deeds office to our office. We had a meeting and the same issue was raised. And you know what, I don't know whether but I think they should continue with, I mean, we agreed in a meeting in terms of on this area, how should they continue? I mean, they proposed that they want to apply for an exemption. They never came back because during that time, Section 37 was not yet in operation. So I don't know, they are quiet. I don't know whether they want to start again to have that conversation with us, because now the Act is in full operation, because they once approached our office on this issue. Do you recall, Advocate Webont?
Yes, Advocate Strom, and just on a lighter note, I wanted to say that it's your favorite topic because we did engage and there were further engagement that was supposed to happen, but I'm not too sure, as you stated, what's the position, but I support your view.
Thank you very much. There's a question from Nkidi who asks, can potential candidates demand information of the selection processes of panel members as well as other candidates? This is now obviously in the interview or recruitment process, and other information of themselves post the selection process. So how does POPIA affect us in terms of interviewing or interviewers or selection processes?
I know it practically as far as PAIA is concerned. In terms of PAIA, we even ourselves has had requests in terms of how the process, in terms of the recruitment and the selection process unfold. So in terms of PAIA, yes, you can. But if you want to balance that with POPIA into place to say, by disclosing that or divulging that information, you'll be disclosing personal information or privacy, then that's where you need to weigh both those acts and to see which one trumps the other. Because what if in access to information is more about transparency, privacy is more about the protection of your personal information. So, and also the issue of public interest, there will override comes into play. So, I mean, some of the issues we'll say them, but I can't answer from a POPIA because it's privacy. All the information that you want there is personal. But from a POPIA point of view, you can make a PIA request and request that information. Thank you.
Thank you very much.
Just to add, yes, thank you so much. Just to add, and I think it's correct. So on a practical level, we have seen people that wants to have information about the candidates, and some people have posed a question about their power or their authority to then issue the names and the details of the candidates. But what is also very important is that the legal department specifically ask if they should ask the participants or these candidates first before they distribute their information, because the purpose for which the information is now required might then not be commensurate with the purpose for which it was originally collected. So as Advocate Strom said, we then need to look at which of the two acts will trump each other. And as we know, there's not any jurisprudence available in South Africa because it's quite a new piece of legislation, POPIA, and it still needs to be tested at various levels at the information regulator and in court. Thank you.
Advocate Strom?
No, sorry, my hand button, it's got a problem. Sorry about that. Sorry.
Okay, thank you very much. Colleagues, I'm just scanning through the questions. As a government communicator, is there consent form that a public member needs to sign agreeing for the pictures and interview to take place? Does it have to be a written form? This is following on principal's question.
No, consent is defined in the Act. Look at consent in the Act. You must explain to a person what is it that they are consenting for. Just look at the definition of consent in the Act.
Thank you
It
very
must
much.
be voluntary, specific, informed expression of will in terms of which permission is given for the processing of personal information. Do you agree, Lebogang, that I should take your picture and I'm going to publish this picture of yours on Facebook or where? Then I'll say, yes, I agree. Something to that effect. Doesn't have to be in writing. Unless in writing, if, for an example, I'm talking at a practical level, but in terms of where we're talking about schools, your government processes, your events, sometimes it's very good that you have that in writing, that expression of will. And it must not be something that is at the bottom of a paper written in fine print. It must be something that somebody understands. So it will depend, you know. I mean, we were at an event and they were taking pictures of us. We were having an event with the South African Human Rights Commission. And my colleagues asked the chairperson, do you consent that we take a picture, you know? And he said, yes, I do consent. But I mean, it was informal, but I mean, to make it legally sound, yes, sometimes it's good that you have something in writing and people know what they're consenting to. So that tomorrow, when they see their faces published somewhere, they don't come back and lodge a complaint with us that you published their pictures without their consent. Thank you. Advocate Wepond.
Thank you, Dr. Strom. I fully support that. And the way to go about it is also just, as Dr. Strom said, looking at the definition of consent, and then also then try to comply with those critical key aspects that is mentioned in the definition. Thank you so much.
Thank you very much, colleagues. Let me just say so far that the questions in the Q&A are dealing with certain thematic areas like family. So in the case of a divorced family, a spouse or a child with related information regarding traveling. Other questions are dealing with HR and recruitment and interviews. Other questions are dealing with the information officer, the registration and their roles and responsibilities. And other questions are dealing with supply chain management and notification of their details. And then lastly, the questions are dealing around webinar itself, the session itself, the registration of the participants and making available the information, as well as the recording of the session and the availability of the slides. So that's just broadly, panel members, the kind of questions that are coming out of the QA. Can I hand over to Mukalani Dimba, who is the Executive for Education and Communication from the Information Regulator. Over to you, Mukalani.
Thank you very much, Louise, and thank you to the members of the regulator and participants. Dino, I hope he's still on the call, and of course, the principal of the NSG. It's been a great experience for me. I've been engaging ferociously with the participants on the chat, answering questions, engaging on some of the follow-ups that have been given. I've thoroughly enjoyed this session. Mine is just to give a very brief summation of what has been covered today. Dino started us off by placing this webinar within a particular context, which is really part of the NSG's efforts at creating opportunities for learning, for peer learning. And he mentioned the idea of the masterclass programs that are being rolled out on a number of thematic areas. And so this webinar today it forms a part of this broader body of work being done by the NSG to help improve capacity of public officials in a number of aspects related to governance. We then heard from Advocate Strom, who took the participants through a presentation on the role of the information regulator, a fairly new entity, but an entity with quite a significant constitutional and legal mandate, presiding as it does over the implementation of two critical pieces of legislation, the POPIA, Promotion of Access to Information Act, and POPIA, the Protection of Personal Information Act, both of them being laws that are giving effect to two constitutional rights, the right of access to information and the right to privacy. We then heard from Professor Sizwe Snail Gamtuze, who took participants through how POPIA seeks to regulate the processing of personal information by responsible parties. I think the major thrust of Professor Snail's presentation related to conditions for processing of personal information. And it's something that came up time and again even on the chat, as well as some of the questions that were posed directly to the panelists. For example, the issue of attendance registers. Perhaps what we should remember regarding some of those conditions is the condition or the principle of minimality. And I've been saying on the chat to colleagues that have been posing questions is that you should always remember this principle of minimality. Some of the problems that we end up encountering in terms of security breaches or data breaches arise from the fact that we tend to collect more information, more personal information than what we need to collect. So in instances where there is a breach, the level of risk is heightened for the data subjects. So one of the things that you may want to consider, just using this example of attendance registers, is do you really need to have an ID number of a person signing that register? Do you need to have their physical address? So perhaps if you go through what you do as you process information, it may help to just think about some of the pieces of personal information that you collect and consider whether indeed you really need those pieces of information for the purposes of which you are collecting the information. So the principle of minimality is one that came out quite strongly, but also the principle of consent, as Advocate Stromzama presented. It's very essential that in instances where personal information is to be collected and disseminated, the consent of the data subject needs to be primary in your considerations as you do that. Advocate Wepont took us through the enforcement framework that governs the work of the regulator. The regulator is a very interesting entity in the sense that it has fairly strong enforcement powers compared to similar institutions or institutions of its kind. The regulator has a quasi-judicial role in the sense that it can adjudicate on disputes arising from the implementation of both laws, Access to Information and the Protection of Personal Information Act. And so it stands in the middle of the responsible party, the data subject, and the courts. It can be a place where you go as an alternative dispute resolution mechanism on any of the subjects that are governed by the Access to Information Act and the Protection of Personal Information Act. So colleagues, it was really very detailed Cook's tour of the two laws insofar as they relate to the role of the information regulator. But we zoomed in quite specifically on the promotion of the Protection of Personal Information Act for this particular webinar. Hopefully there will be more webinars where we will look at the other end of the regulator's mandate, which is access to information. Louise, I think those were the key aspects of the webinar that I wanted to touch on. Thank you so much.
Thank you very much, Mukalani. Sibusiso will be posting the link into the chat box so that we can get feedback on how you have perceived the session. My team and I are very grateful for this experience, to be informed about what the POPIA Act is about and the implications that this act has for us as the National School of Government and all government departments as we work together. There was a very interesting question on the chat box asking what would the other webinar sessions look like? Just a quick word: an in-depth understanding of the regulatory framework underpinning POPIA, the implementation, a focus on POPIA regulations, guidance notes, and the code of conduct, that is in webinar 2. And then of course, the knowledge and understanding of POPIA requirements, able to implement an effective implementation plan and a compliance framework within your departments and in your institutions. So I'd sincerely like to invite every single one to join us in webinar 2 and webinar 3 for a further in-depth study of the POPIA Act. I'd like to give my principal, Principal Bosani Mawini, an opportunity to say a few words and to make the closing remarks. Over to you, Principal.
Thank you, Louise, and gratitude to you and the other colleagues who made this session possible. We're grateful that when we approached the Office of the Information Regulator with this idea, and the Department of Justice, they responded very positively. We thought it was going to be just one session, but as it has been indicated, it's going to be a series of conversations. I mean, as a National School of Government, we are responsible for training public sector employees. And note that I say public sector, I didn't say public service, because everybody who works in an organ of state qualifies to take up a course at the National School of Government, including the courses that we offer for free. So it's not just the ones where we charge, including those that we offer for free. Everyone is eligible if you're in the public sector or you work for any organ of state, except for members of the judiciary. Apart from that, we also convene masterclasses and webinars like these ones, which are meant to share information in order to get public servants to understand important developments like the one that we are discussing today. In fact, I have anxiety, colleagues, Prof. Advocates, and colleagues from the regulator. My anxiety is that in the next cycle of audits, if we are saved in the current year, but definitely in 2023, we are going to see flames as government departments if we do not comply with the provisions of this legislation. So that's why I asked that question about posting of pictures, because it means even ourselves as a National School of Government, if we are in a class and we need to post or use those pictures, we have to get, express consent from those people who are attending a class that this is what we will be doing with this for profiling the work that we are doing and so on. And there's still a lot of gray areas, I suppose. What happens if we're in a conference and everybody willingly comes and stand with you when you are taking a selfie and all manner of things. So there's a lot more that we are going to unpack in the coming conversations. We are hoping that colleagues in various organs of state will take time to read the law as it is and ask further questions, and make sure that also if you are in a corporate management environment, we are responsible for compliance and so on, do not leave outside the colleagues who are in the communication space. There's a new cadre of public servants now, a category of people who are responsible for managing digital platforms. There's a fancy name for it, digital platform type of communicators. These are colleagues who are mainly responsible for making their departments trend in various social media platforms. And for that to happen, they're taking pictures or images of their principals, ministers, and whatever level of the principals may be. And those pictures, then they find themselves in the social media spaces. The risk I see happening here, if we don't provide as much training as possible around how we manage this, is that you may be going to an imbizo and the principal or whoever, you take selfies and you are showing an extremely poor lady who lives in a Ronda village, is dilapidated, and you post those, and then it could trend, she becomes a subject of pity by everybody else. Tomorrow, I do foresee that the lawyers who were making money in the RAF space, they then moved into the health space. I will not be surprised if in the next 4 years, most of those lawyers who were profiting from RAF and the Department of Health will now move and deal and come into this particular space, because we could be sued and they will be demanding compensation and things like those. It is very possible that departments will be facing lawsuits as a result of not complying. As a civil suit, not even before we are audited on whether or not we are complying, because people could then be saying, well, you posted my pictures, you were actually just campaigning for your department or whatever the case might be. Even if you did in the end arrange a house for me, but I became a subject of pity. Everybody saw my difficult circumstance, and that impacted on my dignity as a person. So those are the things that we really and truly need to think about, especially as we are using the social media to promote the work that you are doing. So how do you balance informing the citizens that you are hard at work on a daily basis versus the citizens who want their dignity to be protected? Because at the end of the day, this is what this law seeks to do. So thanks to all of you colleagues for coming. Thanks to the colleagues from the regulator. If they can all of them just open their videos so you will see all of them in one full screen, the colleagues, including the colleagues from the NSG who were organizing actually this event, because we're not using robots, we're using proper human beings like Sbosiso. Most of you received an email from him with a link to attend this. You will have seen that when you were registering, there is reference to POPI in our registration process. We will keep this. We don't use this information because we are audited ourselves. We do need people to register so that we know. I think at peak we had 790 people who were joining this session, and we know who they are because the AG will want to know whether we can account for the people who attended. But thank you very much, colleagues. We will communicate with you. We'll give you a month notice for the next session that will be arranged. I spoke, colleagues, so you know, advocate, Mugelano, who assisted with this, and Prof, that the DGs are the ones who delegated their colleagues to come and attend this session. And in fact, I even saw MECs here. I saw there's an MEC, KZN, Economic Development, Nomsa Dube, she was here. And I did see some DGs, including agriculture, and a number of HODs were also here. So gratitude to all of you. We will give you a month's notice or so when we arrange the next session. I do think, colleagues, that we may have to arrange a session as well for political office bearers, because there are some of them who are very active in this regard. There's some of them who interact with the members of the public and they tell those stories themselves without even mediating. And with colleagues from GCIS, maybe the third session, we must also blend in with government reporters, the media, journalists who cover government, and we can make an arrangement and coordinate with GCIS through their arrangements of convening journalists as well. So thanks to you all. Have a great afternoon. And remember, if you want to post a picture, that you must express consent for those people to post the picture. Remember that if there is a vehicle that is not yours and you are taking a picture in front of the vehicle is not yours, you can't be showing the number plate of that vehicle because we are exposing putting that person at risk. So do not do so. Issues of IDs is a no-no. In fact, even just sharing contact information, you have to make sure that you get express consent for things like those. So thank you, colleagues, and the gratitude. See you. In fact, see you on the 14th. I must make this announcement. We'll see you on the 14th of October at 10 o'clock for a great debate between Dr. Lubisi, former DG in the presidency, together with Dr. Eric Lee from China, who will be debating here on a masterclass of the National School of Government on how to build a meritocratic public service. See you 10 o'clock on the 14th of October. We will send you the registration link. Bye-bye.
Yes, bye.
Thank you, colleagues. Please send our regards and condolences to the regulator, please. Thank you.
Yes, we'll do so.
Thanks, Advocate.